Well, thank you, Stephen, for inviting me to speak tonight to this meetup, and thank you all for being here. My name is Brad Frazer. I'm a partner at the Boise law firm Hawley Troxell, where I practice information technology, IP, intellectual property, and internet law. And so I have had sort of an interesting background in watching the cloud evolve. Back in the day, my friend Reed Disney will remember some of this. Back in the day, I worked at a company called Micron Electronics, the one out in Nampa that made PCs. And I remember that our new CEO was very excited about this thing called ASP, Application Service Provider. And we were going to be on the cutting edge of ASP, right? This was 99, maybe, Reed? Yeah. And so we started buying some data centers, and so we partnered with Microsoft, and we were going to do this ASP thing. And Microsoft was going to rent Microsoft Word to you, so you didn't have any media. And we all laughed and poo-pooed that. Oh, well, that's stupid. That's never going to work. And it just was a little bit ahead of its time, right? Because essentially ASP became this thing now that we refer to as the cloud. So with a group of cloud experts here, why don't we define our terms just a little bit? When we talk about the cloud, what do you think, well, in your experience, what is the cloud in today's terminology? What is the cloud?
Hosted off-premise.
Good. Other definitions or components of the cloud?
You're not going to pull the official definition that they put out.
I am, actually. I have the official definition.
Oh my God, it's like 8 pages long.
The National Institutes of Standards has defined the cloud for us. Read what you mind. It's not the full definition from NIST, but it's a few slides that talk about the definition of cloud. And actually, Reed, would you want to hand those out? It's one page.
Oh.
Yeah, sorry.
Thanks, thank you.
30 pages for reading. And if you wish, you can certainly also use that for notes if you want. But it talks about some elements of the cloud, and I probably should keep one for myself as well. Thank you. So these are definitions drawn from various sources. We have a Wikipedia definition, we have a NIST definition. So we have the notion of cloud computing contains various elements. You see sort of that top slide there, the notion of an application, a platform, and an infrastructure. But there are 5 things that NIST has defined as comprising the cloud, or cloud technology. So we have on-demand self-service is one component of the cloud. Broad network access is another defining characteristic of the cloud. Resource pooling, rapid elasticity, and measured service. And I think those are good. I think we could maybe squeeze a couple of more into that slide, but I think for this group, we probably would agree that that adequately describes the characteristics of cloud computing. So, and then at the bottom, there are a couple of different applications of cloud computing. We have SaaS, and we have PaaS, and we have, how do you pronounce the one with an I? Do you say it IaaS?
Infrastructure as a service?
Yeah, IaaS? Is that how they say it?
I think just infrastructure service. I never hear people
You never hear the acronym?
I never hear IaaS.
Okay. So you see, so we see how that sort of evolved. Now we have different functions, different things evolving on the cloud platform. So as I said, I thought this at least helps us define our terms in terms of talking about what we refer to when we say the cloud. So the cloud has, from a lawyer's perspective, the cloud has changed some of our traditional legal paradigms. Let's think back to, if some of you are old enough to remember, 15 or 20 years ago, sort of a classic computing model. You might have a mainframe, you might have some clients, you might have an occasional bit of code being installed on a hard drive or on a server off of media. Remember those days when the infrastructure was fairly tightly controlled. So has anybody in here been like a CIO or CTO for a long time? Maybe 10 years, 15 years CTO, or maybe IT for 15 years? Okay, so you remember those days when in the enterprise, I certainly do back at Micron, the enterprise was fairly tightly controlled. And the IT department was my client. And so we started with, mainframes and servers and clients, and it was all tightly controlled on a network. And if you wanted to take something home, you had to actually, put it on a floppy drive and get it past security on the way out the door. And so as we watch these cloud modalities evolve, we've watched some of the legal issues change. Now, how does that affect you? It affects, I think, you as users of the cloud. It also affects you as having clients that use the cloud. So I guess let me just by way of a poll, how many of you are in that latter category? Have clients that use the cloud to access what you do? Some? Okay. So, all of us at the core are affected by cloud modalities because Google Mail is a cloud modality, right? Anytime we use Gmail, that's a cloud environment. Anytime we use Facebook or any social media platform, I think we would agree that that's a cloud functionality or modality. But let's talk about some of the legal issues that arise that affect you both as who have clients that use the cloud, and then also as someone who uses the cloud to offer your services. You probably fall into both categories, right? We'll call you both an end user, you have clients who are end users, and you probably also use the cloud to deploy whatever it is that you're doing, I'm going to assume. For example, data centers is an obvious example of someone who employs cloud modality, and Reed has worked in that space. He and I used to work together in that environment. So let's talk about some of the main legal issues that, in my experience, have arisen recently in terms of cloud computing. Let me just make a list here. And by the way, this is written in a little teeny font here, but if you reach out to me either directly or through Steve, I can send you a deck that has most of this information, but I sort of wanted to just keep it informal tonight. So here are some events or legal issues that have sort of arisen in the context of cloud computing. So number one, we have move to mobile. 2, we have privacy. 3, we have data. Boy, oh boy, there's a mouthful, right? Anybody that knows? And then under data, we have several issues. We have SaaS versus a license. 5, sorry. And then contract issues. And so many social media implications. So here's our agenda for tonight, and I know we'll end, Steve, at about, you want to end at like 8:20 or ish? An hour?
It's for the audience as well.
Okay.
So if there's something that's really interesting for you,
Sure.
everyone should jump in. It's a community kind of thing.
Thank you, Steve. That's great. So in my experience, in my client base and in my practice, these are the sort of the 6 main things that clients are concerned about in a cloud environment. And that's a lot of stuff, right? So we won't go through it in great detail tonight, but let's at least spot issues that you in your job or in your environment can at least be aware of these issues as you're interacting with the cloud or a cloud modality. So as a very simple example, like back in the old days when you wanted to put software in the enterprise, you actually bought software and member media would arrive in a box and you would have the IT department would put it on a server and you would download it. That of course that's all changed. And each one of these has different ramifications. So let's start with the move to mobile.
Can I ask you a question about that?
Yeah, sure.
The EULAs that used to come with the software you would buy, you never owned that software, correct? Isn't it
No.
essentially the same?
No, because with a EULA, a shrink wrap EULA or a click wrap EULA, or what's called a shrink wrap EULA, you were granted ownership of the media, the physical media, right? Because you're purchasing and the jewel case. But of course, the copyright to the object code that you were installing remained with the licensor, Microsoft or whomever. You were granted a license to use the object code as it was installed on a hard drive.
Isn't that the same as SaaS?
No, because in a SaaS deployment, you're never actually downloading, having a client-side install of any bits and bytes of object code. It always remains resident on a server. So that's a fundamental difference, Steve, between a SaaS and a license. A license contemplates specifically that you're downloading object code to a hard drive, or that there's media resident on a client. Here, we're moving only in a cloud environment, and there's no download of code. So they're different contractual constructs.
But from a user perspective, it's the same thing. I mean,
Yeah, but it's
even if I own that object code, I can't do anything with that object code.
You know, from an end user's perspective, going to Facebook and using Facebook and agreeing to the Facebook terms of use, a SaaS model, is different than downloading a Facebook app. It's the same, right, to the end user as downloading a Facebook app and having client-side code running on a hard drive. But legally, they're different. They're different to Facebook and they're different to you in terms of the rights that they're granted. So if you own code, it's going to be very critical how you decide what your deployment model is going to be. If you own code, do you want to have a SaaS deployment model, which is very, very different legally and contractually than a license, in which you're granting somebody the rights to actually download the code and use it on a server or on a hard drive. They're different legal constructs. To the end user, they may be transparent.
Okay.
To the owner of the code, Steve, they are very, very different.
It matters to the person.
Yeah,
Okay.
there's a big difference. Okay, so let's talk about the move to mobile and see why the cloud is so directly implicated here. When was the last time any of you actually accessed the internet through a static browser on a desktop or a laptop? Looks like you might be. But I bet there are some of you who go through a day where you don't ever actually use a browser on a desktop, you use a mobile device to access the internet. And over time, that will occur more and more and more. In fact, I saw a slide. Hi, Phil. Everybody say hi to my patent partner, Phil Mackay.
Hi.
Phil is just joined our firm from Silicon Valley. He's does a lot of patent work for Intuit, and so he's very conversant on cloud technology, since I'm glad Phil can be here with us tonight. Phil, that's my chair right there if you want to sit next to my wife Wendy, or you can...
I was hanging in the back,
Okay.
sitting all day, so.
All right.
Good to see you.
So, I saw a slide there from Gartner, some consulting group, maybe it was Forrester, but they said that in May of 2014, hi Jane, how are you? In May of 2014, 25% of all web traffic was through mobile devices. That's up from 13% just a year earlier. The point being, more and more web traffic is moving to mobile platforms. And so we have to consider the fact that the cloud is inevitable. As more and more people move to mobile devices, downloading apps, the cloud is going to be the deployment modality going forward. So our enterprise has to contemplate this shift to a mobile enterprise and think about the legal issues that we confront in a mobile environment. I don't see any reason to think that this statistic is going to change. I think more and more apps and access to the internet will be mobile over time. It was 25% in May of this year. I think that's going to continue to go like this. How many of you are seeing the shift to mobile in your particular environment, whatever that may be? In your enterprise? The classic example, of course, as if you are a CIO or a CTO, the example that I always hear is a CTO client will call and say, our CEO just came in with, fill in the blank, an Android device, an iOS device, whatever the case may be, and said, here, I want my email to work on this, right? So we know that mobile platforms are not going away, and so we're going to have to contemplate this. So one of the primary drivers in considering the legal issues in the cloud deployment or the cloud model is the move to mobile. This is, in my opinion, one of the main things that's driving this. Okay, so let's talk about privacy. Privacy, of course, has everybody up in arms. When you access a website, what's sort of your understanding or expectation about how much of your personal information are you giving to that website in general?
Anything they want.
Yes, but I mean in general, you're at a browser, and what's in general that website going to collect about you? Generally, your IP address, probably, your browser, maybe some information about the hardware, and depending on what you allow them to access, much more information than that, right? Okay. So when we talk about privacy, there are both inbound and outbound privacy considerations that we have to talk about. First of all, remember that relative to cloud privacy, there are only 3 overarching federal laws that govern privacy. Interestingly enough, in the United States, there are only 3 that govern privacy. So when you go to a website, your privacy, your information just isn't automatically protected by some law, unless there are 3 exceptions to that. The first is if your website is one covered by what's called Gramm-Leach-Bliley. It's a federal law that covers financial institutions like a bank. The second is HIPAA, the Health Insurance Privacy and Portability and Accountability Act, which governs health information. And the third is something called COPA, the Children's Online Privacy Protection Act. Those are the only 3. So short of that, there is no overarching federal law that governs privacy in the cloud, interestingly enough. So if that's the case, if there's no law that governs privacy in the cloud, what governs privacy in the cloud? Contracts, privacy policies do. So we always laugh about privacy policies, right? Because they're on every website and nobody ever reads them, and they're just sort of an afterthought. But that's the document that controls both what you do with privacy or personal information that's available on your website, and when you go to a website, it's the governing document, the privacy policy. So one of the principal legal issues that arises in cloud computing is this notion of a privacy policy and how it affects both what your customers or visitors do when they come to your website and what you do when you're on the cloud as well. When was the last time any of you actually read a privacy policy? Maybe peripherally, or you just kind of glanced at it. Well, let's talk about some of the highlights. Well, yeah, let's do it.
The Facebook, how many people downloaded that Facebook Messenger? When Facebook forced you, if you wanted.
I had it long before, and I find that the overreaction to terms is caused more by Android's way they phrase things.
But I mean, they basically said they have the right to go through any contact on your phone. They can call anyone on your phone. If you can read what it says.
But if you look at any Android program, you can access your contacts. It's says the same thing. So anything that interacts with your address book, you grant that permission to. And Google and Facebook should really get that sorted out.
Yeah, but then Google's tracking, from my understanding, Google and Apple track everywhere you go with your phone.
That's true.
And they're storing everyone's phones everywhere they go.
You can, as you know, turn that, you should go to your Google settings and turn that off. Because you can go to Google and you can find a map of everywhere you've been that day because your phone tracks it.
That Google location history is hilarious because it
Yeah.
constantly moves me to Richfield, Utah.
Oh,
Which I have
really?
no idea where that is, other than 400 miles
That's
away.
a different city.
But it will put me there, and then it will put me in Caldwell, and then it'll put me back in Richfield, and then it puts me in Caldwell. So if I actually want to use that to try to figure out what I did on a particular day,
Right.
I have to spend about half an hour deleting all these transports to Richfield that never occurred.
Or just turn it off. Yeah.
So, but do you think that most end users don't even buy
I've got Mr. Scott working overtime.
Yeah. Steve, the answer is yes, most end users don't care. But the point is that there's no other way to protect your privacy online except with respect to the privacy policy. There's no law that will protect you, federal law. Now, there are certain state laws that we'll talk about here in a minute, but remember that. Now, what's the flip side of that? Let's assume that you want to use that personally identifiable information. Let's assume you're a website and you want to collect that information. What does that teach you? What's the flip side? You're no longer a consumer, you're a user. What does that teach you? It teaches you that you can do whatever you want,
Yeah.
as long as you disclose it in the privacy policy. And two important things. And number one, you do the stuff you say you're going to do. I mean, if you really are going to use cookies, you should do that. If you really are going to record their IP address and keep a server log for 48 hours, you really should do that. The other thing is that you need to be able to prove it was a contract. Privacy policy shouldn't be just relegated to the bottom of the 6th page down, 5 pages below the fold, with a little teeny 6-point font link. I mean, now that we understand that's the thing that governs what you do with personally identifiable information, you might consult with your clients and say, well, what do you want to do with this PII, personally identifiable information that we're getting from all these web visitors? Do we want to aggregate it? Do we want to sell it? Do we want to exploit it? What do we want to do with it? You can do whatever you want. There's no law that renders it illegal to do what you want to do unless you are a financial institution, you're a healthcare provider, or COBA, which I missed for some reason. You are a website directed toward children 13 years of age or younger. Those are the three. If you're not one of those, then your privacy policy will govern what you do with PII. Yeah.
Isn't there some sort of rule if you're selling like Germany, Switzerland with PII? I don't know, like internationally.
Yeah, that's the European Union. The EU has a bunch of privacy directives
Okay.
that are really tricky. So you're right, if you do a lot of business in the EU, then you're right, you do want to read, they're called EU privacy directives, and they all have a number, like number 95-6 or something. So yes, to your point, if you are doing a lot of business in the EU, and you are collecting a lot of PII from EU citizens or residents, then you should be familiar with the EU privacy directives. It's a good point, yeah.
But even if my server's in the United States, right, and I contacted someone from like Germany hits, I'm still covered under that policy?
You have to adhere to the EU privacy
Yeah.
laws. If you have a server in the United States and it can be accessed from somebody in the EU, you are legally required
To meet their laws. Okay.
It's true, and then the question becomes who will enforce that? Well, a US court or a US Department of Justice person isn't going to enforce that. The EU would have to enforce that. So they have to get jurisdiction over you in the EU. So you see my point? It's a fairly I'm not telling you to violate the law. What I'm telling you is it's a fairly low-risk proposition. If you are completely US-based and only US servers, and you have a couple of pings from an EU resident, you're absolutely right, legally. But the question then becomes, who's going to enforce that EU privacy directive against you? So it's a matter, it's a sort of a cost-benefit analysis, right? So as we're thinking about privacy is one of the largest legal issues in the cloud because people believe that somehow there's an overarching law that controls their privacy, but it's not true. It's governed by contract law. A recent example of this is that a woman sued LinkedIn in California court because they violated their privacy policy with respect to her PII. It's a matter of contract. She sued them not for violation of some kind of privacy law, but for breach of contract, in essence, under their privacy policy. So that cuts both ways. It governs how you use PII that you're collecting on your website in the cloud, and it also governs how someone might use your PII as an end user. So let me pause there and just ask questions about this notion of privacy being principally in the US a matter of contract as opposed to a matter of overarching law. Interesting, right? But there are some exceptions to that. Many states, particularly California, have enacted privacy laws we have to talk about real quickly here. So even though there are no overarching federal laws, just like the EU gets its finger into that pie, California is very aggressive at getting its finger into that pie as well. For example, let me just read one here. California has a law called, it's called the California Online Privacy Protection Act, not surprisingly, requires an operator defined as a person or entity that collects PII from California residents through an internet website or online service for commercial purposes, which may include a mobile app, to post a conspicuous privacy policy on its website or online service and to comply with that policy. Sounds simple, right? But do all of the apps that you're writing and selling to California residents, your website's not to do your apps? I don't know. So you might ask that question if you're doing coding or you have clients who are writing apps and you're deploying those apps to the iTunes store or through an Android store or something. If you have California residents, are you complying with that California law? Don't know, but you have to have a conspicuous privacy policy that says you were collecting PII and what you're going to do with it. And that's just one state. Arizona has laws, California, let's see, Nebraska, Pennsylvania, Connecticut, Delaware, Colorado. So the challenge with cloud privacy is that although there is no overarching federal law, it's principally a matter of contract. States have now crept up over the past 5 years and enacted laws that impact that. And we'll talk more about the vagaries of state law when we get down here to data. This is really a big deal here. So, summary on privacy. No overarching federal law, principally a matter of contract, both in and out, good and bad for you, depending on what you want to do. Do whatever you want with that PII, as long as it's disclosed in the contract, and you do it, and you can prove that it's a contract. How do you prove something's a contract online? There's no signature anymore. How do you prove something's a contract online? We do it all the time as lawyers, but how do we do it? Just common sense. How am I going to prove that you went to my website, saw my privacy policy, and agreed to it as a matter of contract? Common sense. How are you going to do it?
It's part of the workflow to get on.
Okay, good. Just as a normal matter of anybody accessing the website, they have to go past a portal page and conspicuously in 12-point font at the bottom it says, read our privacy policy before you proceed. That's called a browser app license. Very good. A browser app contract, there's actually a name for it. Very good. How else?
Make sure they get to the end.
Sorry?
A lot of times they make sure you scroll down to the bottom.
Okay, good. You force them to. A perfect solution would be to have somebody click on an I agree button on it. You don't ever have to click on an I agree button on a privacy policy, but you should.
Apple does that, doesn't it? When you
Yeah.
install an Apple
They do.
app, they force you to scroll down and hit the button,
Right.
which is so annoying.
But we now know why they do it, because they're creating a contract. Being Apple, they can force you to do it, right? What other ways? Just common sense ways. Prove there's a contract with this person who viewed your privacy policy on your website.
Email to you.
Good. You just keep server logs. Keep server logs of all the IP addresses. And that's not perfect, right? Because they may not have a static IP address, but it's better than nothing. You keep a server log that has all the IP addresses, and you prove during the litigation where they were when they logged in, and you get the IP, it's like that. Just common sense stuff. But you're trying to prove, the legal term is what's called a manifestation of assent, A-S-S-E-N-T. Have to prove they agreed to it. So be thinking about that. Knowing now that privacy is principally a matter of contract, think about that both as a purveyor of websites or a coder or a developer or whatever you are. Think about the importance of privacy, being able to prove it as a matter of contract. Remember that the only 3 overarching federal laws are financial, health, and children's stuff. And then be cognizant of the state laws that affect privacy. And if you're writing apps and selling to California consumers, please be mindful of the California Online Privacy Protection Act that says even your apps have to have privacy policies, not just websites.
Do they define conspicuous in that law? I mean, if it's
Yes.
on the help menu under About.
Yeah, the answer is yes, they do.
enough.
The answer is that it has to be, it has to be conspicuous as determined by the judge, meaning that relative to the surrounding font, it has to be noticeable to the average consumer. They don't say like it has to be 16-point font.
So if it's located on the help menu, that's not going to qualify.
I'm sorry.
So if you had to go to help and then click on privacy policy, that probably would not qualify.
I don't think so. Yeah, I
You
don't think so.
would want it right there the first time the app opens. Hey,
I
here's
think-
our privacy policy, and whether or not people click it, that's on them, but it was presented to them, they had the option.
I am hiring you to write my app. That's exactly right. That's very good. What's the downside of not complying?
It's part of the sign-up process. If you don't comply, you don't get to sign up.
Very good, but I mean, as a legal matter, what's the risk to you or your enterprise for not
I think
complying?
that I think what you say you're gonna
That's right. The risk, let's just talk quickly about the risks. The risks are, number one, like LinkedIn, you'll get sued for breach of contract, or you'll get sued by the California Attorney General's office for violating a statute, or you'll get sued by an individual user because you didn't abide by the terms of your own privacy policy, or you could get sued by the Federal Trade Commission. I mean, so there's a lot of bad stuff that could occur for not sort of taking this cloud privacy thing seriously.
But if you don't have a privacy policy, how can somebody sue you for breach of contract? You can do anything you want. You don't have a privacy policy for them to hold against you.
See, this is how Reed thinks. You see how he's always trying to skirt the law? And Reed, that answer would have worked 10 or 15 years ago, but it doesn't work today because privacy policies are so commonplace that the court would imply one onto your web relationship. The court would say, well, Mr. Disney, you run a search engine. You don't have a privacy policy. We're not going to let you skirt the law. We're going to make you abide by Google's privacy policy because that's a close competitor, because that's an industry standard privacy policy. So it's very clever, and that would have worked a long time ago, but it won't work anymore. They will imply a contract to govern that online relationship. They'll imply a privacy policy. Very clever, though. Other questions about privacy? Okay, let's move down and talk about data. Holy cow, is this a big deal? Get it? Big data? Nobody got that? Have you all seen the movie Pulp Fiction? Where Lawrence Fishburne's character says, say what one more time? You've all seen that line, right? And you've seen the meme that's going around, say big data one more time with Lawrence Fishburne's character. I love that meme, it just cracks me up when I see it. So we have to talk about big data, right? Okay, so there are basically 4 issues with data under the notion of cloud computing. The first issue is data security, of course. Both your data, you personally, your data, when you go upload your information to Netflix or whatever, and then your client data, when you're writing code and you're uploading your client information to the cloud. So we have both your data and your client data. So there's data security, number 1. Number 2, data breach. You've been hacked. Holy crap, what do you do? Your server's been hacked, Target was hacked, what do you do? 3, big data. We'll talk about big data. And what do you do it? And how do you make money from big data? And lastly, who owns the data? That's a big deal. Have you ever thought about that? Who owns that PII? Who owns it? Does the privacy policy declare who owns the PII? Have you thought about that? No. Privacy policy only says what we're going to do with it and our protocols relative to interacting with it. It doesn't necessarily say who owns it, which is an interesting issue. So let's break that down. Now, first, data security relative to, first of all, your data. Anytime you're putting data up in the cloud, what types of information might you be committing to the cloud? Name, address, social security number, phone, birth date, medical information, credit card information, employment histories, all that stuff. When's the last time you applied online for a job? Think about the information on that job application online at Indeed.com or Monster.com, and you uploaded all that stuff. You are entrusting your personal data to the cloud. How is that data secured?
Hopefully well.
That's well said. That's a mouthful. Hopefully well. But what are some of the legal issues around data security? What protects your data in the cloud? Do we know? Hopefully well, but what protects your data in the cloud? Guess what? Once again, it's principally a matter of contract, once again. So we are all familiar with these things called service level agreements, right, that attempt to give us contractual basis to say how they're going to protect our data. And it's also a matter of the subscription agreement that you subscribe to when you decide to upload your data. So, for example, Monster.com, have you read their terms of use? And does it say anything about what they're going to do with your data when you upload this job application? I don't know. But it's all a matter of contract. How they secure your data, your personal data, is a matter of contract. There are laws that tell us what happens when there's a breach, but there isn't a law that specifically says you must secure customer data. Isn't that odd? I mean, we know what happened when there's a hack, but there isn't like an overarching federal law that says you have to protect it. It's once again a matter of contract. So what does that teach you on the converse side when you're uploading your client data? Someone hires you to develop an app or whatever the case may be, and you're uploading that data into iCloud, right? Have you read the Apple iCloud agreement? Do you know what it says relative to your customer data? So you're developing an app and you have all this, let's assume you have a database with 10 million records in it, right? And you're developing an app and you upload what to Dropbox or to iCloud or to some cloud storage modality because it's 10 million records. But before you do that, you have to click on an I agree button that says, these are the terms that govern your uploading your data to the cloud. What does that contract say? How are they securing it? Where does that data reside? Has it suddenly been offloaded to a server in Ireland? Is it now on a server in the Cayman Islands? Is it in an ultra-safe data center like Reed Disney runs, or is it in some guy's server out in his backyard? You see the point? I don't mean to beat into it, but you see the point, right?
They don't tell you. I don't think a cloud provider tells you where those.
Well, they don't, but you at least should have the due diligence to read the contract and inquire before you upload your client data to the
They'll tell you
cloud
that they're
provider.
on secure sites.
But oftentimes what they will say is they don't own the data that you upload and they hold no value to it. So if there's a loss, there's no value to sue for because they said, whatever you put here's yours and it has no value to us.
And that would be good or bad relative to your client data. That would be bad.
Well, me as a provider, that's great.
See, and so it just cuts both ways. It's a
Yeah.
matter of contract. If you're the cloud service provider, that's good for you. But if you're uploading client data, that would be bad for you
Mhm.
because you're assuming a risk that you want at least them to be partially responsible for. So Steve, to your point, you don't know where the data is going to go. But let's assume, for example, Steve, that a client asks you to make warranties. Let's assume someone hires you to do this project I mentioned with 10 million records. And they say, because they've lawyered up, they say, we want you to guarantee the safety of our data.
You
Right.
can't.
So what does that teach you about your end user contracts with your customers? What types of warranties should you be giving?
Not much.
Right, that's exactly right. That's the whole point.
I mean, you can never guarantee the data that's stored on some server somewhere
Well,
will
you
last.
can not accept a boilerplate negotiated contract that has the terms that
Yes,
satisfy what you need.
you can try that, but as you know,
With the cloud provider? You got a small one.
most, well, see, that's exactly right. Most cloud providers, it would be difficult to do that unless you have a great deal of horsepower in negotiating leverage.
With some of the new data laws that are coming out of the EU, this is something that's having to be focused on. We're actually looking at that right now, is in how do we guarantee that customer data stays within the EU and in some cases within specific countries.
Right.
But I think over the next couple of years, we're gonna start seeing more and more contracts say, your data will stay right here because of, you know,
New
because
Zealand-
say, listen, the verbal cell.
Well, New Zealand just did that, right? Did New Zealand until a couple months ago said all data had to stay in New Zealand, and now they've said, well, that doesn't work, so now your data can leave. But I never understood that. If my data is in New Zealand and I access it from the States, the data has left, right?
So I mean, in that case for us, it depends on what that data is. We actually have geolocation stuff now that says that you have to access it from that country. You leave the country.
And you build out the app to block it.
So why is it that then so many companies are insisting that their data storage facilities and hosting centers be in Ireland? What's favorable about Ireland under the EU? Do you know?
Income tax avoidance.
Well, yes, but I mean, there are specific provisions why many cloud data storage companies specify Ireland as the place of storage.
But then I think that's a lot of it is because most of them are in Amazon, and that's where Amazon storage is in Ireland. And so
Amazon Web Service, yeah,
Microsoft has a thing to it.
and as well. It may be more, you're right, it may be more business function than an actual EU data loss function. I just haven't ever looked
But
at
I would
it.
imagine Ireland would be easier to deal with than like Germany.
Do you know, Phil, by chance?
Why they choose Ireland?
Yeah.
No.
Okay.
I mean, I just see AWS thing. I've
Yeah.
seen this from, he's talking about, people that I wrote the applications where they do have the power to say, you will do it this way. So I've seen, I haven't seen it as a small one.
Okay.
Or a big one.
But if you're a small, if you go into a service provider and you don't have the leverage,
Right.
you're still gonna be dealing with the ambiguity of their waivers and their best efforts language, some of that. And how do you, other than mirroring that in your own contracts,
You run multiple cloud providers.
well,
You're right, that's very good, that's a good business answer. I think the legal answer though is this. So you have a business, right, and you are doing stuff that causes you to upload your client data to the cloud, whatever that means in your context. And the contract with AWS or iCloud or whomever says no warranty, no protection, no security, we don't guarantee the security, we don't guarantee it against hacks. So what does that mean for you as a legal matter? Okay, as your lawyer, I would advise you, number one, you should form a limited liability entity of some kind. You should have a corporation or an LLC, of course. You should never be a sole proprietor. Number two, you should have extremely robust insurance, business insurance that guards against cyber liability like incursion and hack. Number three, your contract should all be very vague on the notion of any sort of warranties relative to data security or redundancy or any of those things that you can't get upstream, right? Or 4, take it in-house. Find a web provider, a cloud provider that can give you those warranties. Find a local data warehousing place like Involta or whomever that will give you those protections and negotiate a better contract. Those are the 4 legal answers I would give you to that.
And but the reason the bigger providers don't give you those protections is because technically they can't. The technology doesn't exist to provide those guarantees. So going with a smaller provider isn't going to help. It'll actually be worse because they have a lot less security built in.
But remember, what we're looking at it from a legal perspective. We're thinking of it in terms of litigation. My first 8 years I was trained as a litigator, so I always think about lawsuits. So I'm thinking about, I'm trying to create for you as my client a defensive position when you're sued. That's all I care about, right? I don't care if the data's lost. I don't care. What I care about is giving you a defense when you're sued. So suddenly, you get sued on these facts. What are the defenses we roll out? Number 1, your personal assets are protected. Your summer home in McCall is protected. Your Lamborghini is protected because you have a limited liability entity with $100 in the bank and you bankrupted. Number 2, you have extremely robust insurance in place, so you don't have to hire the lawyers. The insurance company hires the lawyers, and you're on vacation in the Bahamas. Number 3, your downstream contract to your client says nothing. There's nothing to sue you for because there's been no warranties given, and there's been nothing they can sue you for. So, you know what, candidly speaking, cynically, I don't care as a lawyer what happens to the data. I'm trying to protect you as my client to give you a defense when you get sued. That's what we're talking about, right? That's what I'm talking
But
about.
I do think a lot of the small providers, a lot of them are actually fronts for the big cloud providers. I have a buddy of mine, we set up in Jordan of all places. We're a Rackspace reseller in Jordan. And we're a cloud provider, we're the only cloud provider in the Middle East. And of course, no one has to know how we supply it. That's another issue with local cloud providers is listen and don't do it themselves.
So the point with data security is that, again, like privacy, it's principally a matter of contract. Principally a matter of contract. So think about, where are you in the data stream? Are you uploading it to the cloud, or are you receiving it from the cloud? And whose data is involved, yours or your clients? Read the contracts, and to your point, what we're doing is we're trying to think legally about creating a defense when you get sued. That's what this is about. And if you've done it right, you will effectively be insulated from that liability. That's the point. That's what we're talking about here. That's why we're talking about privacy policies, to give you a defense when you get sued. That's what a good lawyer is supposed to do. Yeah.
Maybe I'm just not aware of it, but like Target, for example, I mean, they took a huge hit, but did they actually is there actually actual real litigation in addition to
Yes.
all the money that they've also lost?
Yes, they're being sued. Target's being sued too, yeah. And so hopefully Target will be able to deploy some of these defenses in that lawsuit, like, well, clearly they have a limited liability entity. They obviously have very, very good insurance. All their contracts provide no warranties relative to data security at all, I assume. So they've kind of laid out all those defenses. But why is that still not a perfect answer to the litigation problem, Jeremy? Why is that still not a perfect answer?
Because you really have people would expect it, a rational person.
Well, that's right, but more cynically and practically, lawyers aren't free. So unless you have insurance, even though you're going to win, you're still going to come out of pocket a lot of money to defend that lawsuit. So we're just trying to have proactive measures to create these defenses, and that's why I will underscore to all of you who are sole proprietors or small companies, LLC and get insurance. LLC and get insurance.
So earlier you mentioned that there were laws around what you have to do when there's a breach.
Right.
Is that only for PCI, or are there other laws?
Yeah.
Where, if anybody gets hacked, do they automatically have to disclose, or what's the?
It's a good question. In fact, let's move to that because that's next on the agenda, and that's data breach. So there's a hack. So the first issue that lawyers think about is, as we've been discussing, have you breached a contract? Did you have a contract with anybody downstream from you that says you will you guarantee there won't be a hack? Hopefully not. But you may have a contract with somebody that says we will secure your data against hacks. So the first issue is there's been an incursion. Are you going to get sued? And we have to go into defensive mode there. But to your point, what are your obligations in the event of a data breach? And the challenge is that there is no overarching federal law, that unlike the other two, where they're matters of contract purely. Each state, almost every state, 40 states now, have data breach reporting laws, and they're all different. So, for example, if you suffer an incursion and your server's hacked and 287 client records are compromised, and you have 35 different states represented, guess what? You suddenly have an obligation to know what the reporting obligations are in those 35 states, notify those consumers, under that state's data breach law. So to your point, some states may be very aggressive. California's data breach law may say any incursion, you have to report it. But another state like Louisiana might say, you only have to report the hack if PII is compromised and a social security number and a credit card number, those 3 things. But it varies from state to state. So this is why I am encouraging all my clients to source and buy, in addition to the liability insurance we've been talking about, data breach insurance, which is a big deal now, because the burden on a small company of identifying and complying with 40 disparate data breach laws is challenging. You can do it, but it's very, very difficult. You're going to take a full-time resource, a couple of weeks probably, to figure it all out and do all the notices.
What's the law that applies to it? Is it under the geography where the data resided?
No, it's the state of residence of the individual whose information was compromised.
Okay.
So for example, if you have a business in Idaho and you sell something through an e-commerce modality to a resident of Vermont, for example, and there's an incursion, and that customer's PII or whatever the Vermont statute says is compromised, then you have to notify that individual in Vermont. And you may have to notify the Vermont Attorney General as well. It just depends, it's state by state.
Okay.
That's only if your data sits in the state or your patent states. What if you're a foreign company?
No, you're still subject to it. It depends on where the person whose information is compromised resides.
So if I go to a company that's sitting in Turkey, for example, who knows, and my information gets hit in Turkey, the U.S. government's not going to call Turkey. Well, maybe Obama, but they're not going to call Turkey Obama.
Well, is anybody in your hypothetical, does anybody reside in the United States?
But if the company doesn't, then when I sit here in the U.S. with the company, because a lot of times you interact with companies on the web, you actually don't know where they're from.
So for your hypothetical, Steve, you're the one whose data was compromised, you personally.
Well, I'm just doing an example.
And well, again, it depends on where you live. It depends on where you live, Steve. If you live in Idaho, then you have that company in Turkey has to comply, yes, with Idaho's data breach reporting statute. Now, as a practical matter, is the Idaho Attorney General ever going to go seek and sue a company in Turkey? I don't think so. For enforcement, but you're the one who's penalized, right? You're the one who suffers because you have no recourse and you never get noticed. The whole point is to give consumers notice of a hack so you can be proactive and protect your PII, right? To get your LifeLock subscription going, right? If you've been hacked. So on your hypothetical, if you're in Idaho and your cloud provider's in Turkey and your information is compromised, okay, the guy in Turkey gets away scot-free, but that's not good for you, the consumer, right? That's who we're trying to protect.
So you have to protect yourself to know who you're dealing with on the web and where that company's from. I don't think you ever do that.
Sure. I mean, I think you would think twice before uploading a lot of PII to a company in Turkey.
If you knew that.
For example, if you knew that, right? Again, that's why reading the contracts is so important in this space.
So how would it work if, as the end user, right, you and the company's got its user agreement, and you agree that they own all of your information, you're releasing it to them, so it's really their data at that point, and they're hacked, but it's excluding the credit card and social security number and everything else. How is the company liable if you've agreed that they own your information?
It's a subtly different issue than the notion of a data breach reporting obligation.
Okay.
You may be insulated from a lawsuit from that end user for breach of contract. That's different subtly, isn't it, than violating the Vermont data breach statute.
Okay. So you're still required to notify them.
That's right. It's all going to depend on the language of that statute. And they vary. I don't know how else to say it. It's state to state.
Okay.
Some states are very aggressive. Any incursion you have to report. I had a client who had 50,000 records of California residents, but no PII was really lost, but they still suffered a hack. And the hacker from Russia, of course, touched 50,000 records, didn't do anything with it, didn't download them as far as we could tell, didn't copy them, no PII was compromised, but there was still an incursion to report, there was a hack. 50,000 California records were looked at. We still had to report that to 50,000 California residents because of the California statute. But we didn't have to report it to, I don't know, pick one, Oklahoma, because the Oklahoma statute was different.
What is Idaho's statute? I don't know.
You know, I should know this off the top of my head, but it's kind of middle of the road. I think I would answer it by saying if you are in Idaho and you suffer a hack, you should at least ask if any Idaho resident's data has been compromised or touched, and then just get online and Google Idaho data reporting statute and comply with it. But of course, that's the easy part. The hard part is finding out and complying with the laws of all the other potentially implicated states. That's the challenge of data breach. So the good news is at the moment, well, bad and good, there is no overarching federal law. What we of course need is an overarching federal data breach statute that gives us one rule. At the moment, we don't have that. So if you're playing around in the cloud and you're hacked, just remember data breach. And you may have a reporting obligation, and it may be different among the various states that are affected. Okay? Questions about that?
Yeah, here's a question kind of left
Yeah.
field. So why don't we have overarching laws? Is it because overly conservative states' rights kind of?
Yeah, it's a complicated political question. Like, for example, we don't have an overarching law that governs something called trade secrets. Every state has its own trade secret law. There is no overarching federal law that governs something called the sale of goods, commercial transactions. It's called Article 2 of the Uniform Commercial Code. It varies from state to state. It's just states' rights, states' autonomy, and they're just, although this is an example that screams out for an overarching federal law, there just isn't one in the data breach space, not today. But it would be, I have a feeling that there should be one soon enough.
You would think.
And the other challenge, of course, is getting consensus, right? You have to get consensus at a federal level. So some states, like California, would want a very aggressive federal data breach statute. Can you think of any states that might not want such an aggressive data breach statute? There are some, right? And so you have to build a consensus. Some states may say, we don't want the federal government intruding in our business and knowing that a hack occurred. Do we really want the FBI knowing that a hack occurred here in Idaho? You see my point? So that's probably why. Okay, so we've talked about data security, we've talked about data breach, the reporting obligations that you have. That's the scariest thing in the whole data space, in my opinion, is you have a hack and you have to report it. It's really a big deal. If you don't report it, and the times are critical, like you have some states you have like 48 hours after the hack to notify the affected individuals in that state.
After the breach or after the breach is discovered?
Sorry?
After the breach
Yeah,
happened or
well,
was discovered,
yes,
I would
of
say.
course. Once you're on notice of the hack, then you've got, to some states it's as little as 48 hours. It's a big deal. Like, so you get notice on a Friday? Yeah, it's 48 hours. It doesn't say business days. It's 48 hours, right? So, I know, it's terrible. Yeah, that's why it's nice to have insurance, because at 5 o'clock on a Friday, you just call up your broker and say, hey, Charlotte, we had a hack, handle it, you know, and Charlotte goes to work. So, all right, let's see, data, big data, big data. Why is big data such a big deal? Why do we care about big data? Capital B, big, capital D data. Why do we care? Why do you care about big data?
Money.
One word, there's one word answer for this. Money. Money. A lot of money is to be made in big data. And now we have the processing power and the analytical tools to extract big data when we didn't before. So because of the cloud, how many terabytes and what comes beyond terabytes? Petabytes. How many petabytes of data is floating around in the cloud with information about consumer behavior and zip codes and buying information and movie reviews or movie ticketing purchase information and Amazon website clicks? How much is floating around? Petabytes, right? So it's all sitting around in the cloud. Think of the value that can be extracted from that. If somebody could just go into the cloud, coalesce all that big data, make it usable through data analytics, and then sell it. Everybody gets that, right? That's why big data is such a big deal now with the cloud. Because before, the data wasn't all in one place. It's all distributed, right? But it's in the cloud, you can get it. And second, we really didn't have the computing horsepower to meaningfully extract it, and now we do. It's storage. So the question becomes, what about big data? And it basically ties back to the privacy policy. So we have to think again in terms of our privacy policy and our contract in terms of what we do with that big data. So you're Google. How much big data do you think Google is sitting on? Billions, maybe millions, but maybe billions of dollars worth of big data, maybe, right? So your privacy policy is of paramount importance because it will teach what Google may do with your PII. Right now, Google is making money off of your last web search, right now. Amazon is making money right now off of your last search for products and purchases on Amazon because you've contributed data, the privacy policy gives them the right to do so, and because it's big data, they are now exploiting it. Are you exploiting big data? Does your company care about big data? I don't know. I mean, if I were the CIO or the CTO or the web guy for a reasonably sized company, I would ask the question, is there any big data we can extract? Can we extract it? And to whom may we sell it? What about something as simple as zip codes or IP addresses? or pings, or search results. What about that? Can you sell it to anybody? Does anybody want that big data? You should all be going, yeah, of course, everybody wants that big data. All marketers want your big data. It's just waiting to be sold. So what's the gating question then? What's the gating question that you now know to ask as to whether or not you can exploit that big data? What's the gating question? I'm just going to wait you out.
What's my privacy policy?
Read A+ answer. What does my privacy policy say? So if you suddenly want to start monetizing an before now unexploited asset, big data, in your enterprise, change your privacy policy if you need to say, whenever we own all PII, we own it. And you give us the rights to use it and sell it and exploit it, and it's completely lawful because why? It's a matter of contract. There's no law that forbids it. So my advice to clients in the big data space is, holy crap, if you can find a way to collect and exploit your big data, do it. Tons of money to be made there. All you have to do is make sure your privacy policy allows it. On the flip side, as an end user, ask the question, do I want my big data sold and exploited by the Amazons and Googles of the world? And you just have to read the privacy policy and ask that question.
So is there an app or like a little plugin to the web that every site I hit, it pops up and tells me if it's an evil privacy policy or not? So I can have like a little mini you on my machine as I go from each website.
It's a genius idea. Give it some artificial intelligence, right? And have it. It's a great idea. Why don't we do that? Why doesn't somebody code an app that reads the privacy policy and quickly scans it with some artificial intelligence?
And then ranks it as good, evil, or...
That's a great idea. Anybody want to do that? That's a great idea.
Until you get sued.
But most people aren't
And
gonna
then, and then a little pop-up comes up that says, green, yellow, or red based on privacy, based on the AI and the app that is reading the privacy policy before you go to the site, right? I'm not aware of them, but it's a good idea.
I don't think most people are gonna care, personally. I mean, they're not gonna stop using the Googles, the Facebooks, and everything else, so.
They're not. You're not. But to your point, Steve, it's a really good idea, but it does teach
Make
the
short-term
fact that
money.
somebody should be mindful of that, particularly if you are in a position in your company to now be exploiting and monetizing PII through big data.
And if you really don't want your data collected, if you're using a browser, and I know you said most people are getting away from that, but most of us in the real world use browsers every day, you can go in and set your browser default settings to not allow collection of personal data.
Sure.
So there's lots of ways, if people do care, there's easier ways than an app that scans privacy policies.
Agreed.
If you're using browsers.
Agreed, and that is a terrific practical answer, and the legal answer is it all boils down to a matter of contract. That's the point. Privacy today is still principally a matter of contract. Okay, so let's see. I think we've answered this, but let's ask the question, who owns the data? Who owns it? Let's just mull that over for a minute. Who owns the data? Someone goes to your website, and just by virtue of them interacting with your website, you collect some PII. IP address, zip code, search history, geolocation. Who owns that data?
Depends on your privacy policy.
Very good. I'm so glad that somebody's been listening. It depends on the privacy policy.
We've listened.
And if you stipulate in your privacy policy that you can ensure that they have what? Agreed to as a matter of contract because it's conspicuous, then you may own the data. And you may use it and exploit it and sell it. But if not, to Reed's point, if you try to skirt the law and not say anything about the data, it would probably default to you don't, as odd as it sounds, it would probably default to you don't own it. So this is one case in which I would strongly recommend that if you want to own that data, you have a privacy policy. But what about just general contracts? 5 years ago, when I was negotiating contracts on behalf of my clients, do you think I would have ever asked the question to the other lawyer, well, who's going to own the data? That comes up in every contract now. Who owns the data? It's like a standard clause now in all of my cloud services or web services or in internet law contracts. Who owns the data? And why? Because it has such great value. So
it can also be seen as liability to other people.
Pardon me?
It's also a liability depending on where you're looking at it.
That's true too. But we're thinking of it in terms of an asset that we can exploit and monetize. Mm-hmm. So think of that when you're entering into a contract with a cloud provider or a web host or a web developer. Let's assume that you hire some guy to do database design, database development for your company. And there's going to be certain data created through that process. Who owns the data? It's a question that you should ask. If your company wants to own it and exploit it and monetize that as an asset, ask that question, who owns the data? And it's a matter of contract law.
And
okay.
What if I've been collecting data for 10 years and I put out a privacy policy today and there's nothing in my data that says when I collected the data? Now what?
Oh, so you changed it since.
Well, maybe I never had a privacy policy ever before, and I go out now and say, well, let me go find it.
Let's think that through. So you today, tomorrow, because you were here tonight, tomorrow you implement a privacy policy that says, I own all your data, and I can exploit it and monetize it if I want, and essentially like that, right? And you make it conspicuous, and there you go. To the point Reed made a moment ago, if someone who had given you their PII 2 years ago, before you had that privacy policy, you attempted to enforce that contract retroactively to them, it would not be effective as to them.
But how would you know if they entered it today or if they entered it 2 years ago, especially if they were if you can prove they were on the site both today or tomorrow?
So somebody who gave you their PII 2 years ago finds somehow that some third party has their PII. And they go, well, how did this third party get my PII? And they track it back to you. And they sue you for some type of breach of contract or some theory. You would have to prove as a defense that the contract was in place and they agreed to it. They don't have to prove that, you do. It's a defense.
So if the person gave her their PII 2 years ago and then visited the site again tomorrow, she would have an argument that they accepted the privacy policy if it was conspicuously.
You have an even stronger argument if you emailed your customers with the notification of the privacy policy change and told them if you continue to leave your data here after 3 days, whatever, a reasonable time.
And who just recently did that somewhat conspicuously?
I don't know, I see that stuff.
eBay did that. eBay did that not that long ago. They sent an email out to all their users and saying, our privacy policy and our terms of use have changed. So this is exactly why. So if you wanted to do that, that's exactly what you would do. You would send out an email to all your users and say, our privacy policy has changed. Please go here and read it. Click on the link to acknowledge that you've read it. Your continuing use of our services will indicate your acknowledgement that you agree to our new privacy policy. That's how you would do it, to clean it up retroactively.
Microsoft just did the same thing recently
Yeah.
with Bing too, right up at the top where you type in the search, our privacy policy is changing, click here to find out more.
And I'll bet you nickel that if you read it, it's going to go to some type of big data issue. That's why all the privacy policies are changing now, because they want to collect and exploit big data, because they know how much money is to be made there.
Is there any law around like coercion of customers? Saying whenever say, oh, well, I have to use Facebook, I shouldn't have to agree to everything I want to make you agree to.
You don't have to.
Well, I know, I'm just asking, asking if anything in that direction has ever happened.
No, not that I'm aware of.
That's what compulsion, that word.
Not that I'm aware of. Okay, let's move on and talk now about, well, we're doing fine on time. Let's talk about this. This is somewhat esoteric, but it's important. Let's assume that you have an app. You have created a work of software that you own the rights to under copyright law as the author of that code. So when you write lines of source code, you literally are creating a work that's protected by copyright law. You own it unless you give it away to somebody else under some arcane legal theory. But in general, the human being who types the lines of source code owns the copyright. You may then control how other people use that source code, which has then been compiled into object code, right? So you control how they use it under a license. A license is a very specific legal document that controls how someone uses, or more accurately, infringes on your copyright, because you're giving them a copy of the code. It will contain provisions that are different than a SaaS agreement. A SaaS agreement does not contemplate that you're giving anybody a copy of the object code. It remains resident on a server. No one is getting the actual bits and bytes, except maybe some kind of phenomenal applet interface or something. But as a general rule, this contemplates a client-side download or installation of actual object code. This does not. Why do we care? You care if you're an end user because different rights are given under each scenario. They're different. So if you are an end user and you need the rights to, do something with the code that's specific to your enterprise, a SaaS deployment may not work for you. You may need an actual license agreement, but the code may not be available on a license. You may be stuck using a SaaS deployment. Or alternatively, what if you are a code writer? Do you want someone to have rights to your code under a license? Probably not. You probably want it to be a SaaS deployment. So for example, let's assume that you have a completely SaaS model and you use a template agreement that contains license language. How do I make this not horribly esoteric? You have a server and it has code running on it, okay? And you give somebody a username and a password. That's a SaaS model. There's no client-side download of code. But your user agreement has language in it that can be specific to a license a license. The end user reads that and they take liberties with respect to the code that they shouldn't, because the license is more permissive relative to the code than this thing would be. I just don't know how else to say that. So I guess the moral here would be, are you an end user or are you a provider of services? If you're a provider, think carefully if you want a SaaS deployment model or a licensed deployment model, because they're legally different. If you're an end user, read the agreement and say, is this a SaaS deployment or is this a license? And they just are legally different. And I don't know, I don't think there's anything more to be said on that other than just to ask that question, because they have different rights granted to you depending on the model.
What are apps considered?
Apps?
Yeah, like apps that I download on my phone that are mostly internet-based, but actually install code.
You know, I guess it depends on how much code you're actually downloading to the client. If I was the lawyer for an app company and I was the client, my client was actually downloading code to the device, I would cause that to be a license agreement. Because for example, one of the things a license does is it says, thou shalt not reverse engineer the object code, take the source and monkey with it. That's something that says in a license agreement. So if there's a client-side download, I want that language in there. I don't need it in a SaaS, because they have to hack a server to do it in a SaaS environment, right? But if there's a license, I've got to make sure that it says, you will not discover the source code and create a derivative work. That's a copyright law thing, and that's something that would be in a license agreement. So the answer to your question, Jeremy, is it depends on whether there really is a client-side download of code. And if there is, the lawyer should say, you need a license, not a SaaS agreement. There it is. It just depends. Because you've got to protect the client's code. Yeah?
So what about like a single page app that you can run offline? What does that qualify as?
That can run offline? Well, then I guess that would be a license, because that contemplates in my mind that there has been a client-side download of object code that's running in some kind of a client environment, right, if it's offline. So that would probably need a license. So, you know, and I apologize, this is an esoteric concept, but I wanted to at least mention it so you can spot the issue. That depending, you may want a SaaS agreement or a license agreement. It's just going to depend. Okay, what do I have under contract? Contract issues. Oh yeah. You know, this issue here about the move to mobile is interesting. Let's think about it from this perspective. Let's assume that Reed is a salesman for HP. And Reed is in the field with his mobile device, and he's about ready to close a sale. The customer already has a contract with HP Legal that says, we will buy tablets for $3.99 a piece. The customer says, Reed, I'm about ready to buy 100,000 tablets for my school district in Nebraska. $3.99 is too much. You need to sell it to me for $3.89. And Reed, with his mobile device, sends a text message that says, okay, school district in Nebraska, I'll quote it for $3.89, we'll do a deal. Guess what? Reed is now, under the doctrine of apparent authority, formed a contract between HP and the school district in Nebraska. And he's modified the essential terms of the underlying sales contract. And his employer is now going to get $10 less per tablet than it would have under the contract. So the cloud and the move to mobile changes makes things really, really messy for the enterprise, because you have everybody out there with mobile devices altering contracts, changing warranties, and doing all these other things that create problems for the enterprise. Back in the old days, that was still possible, but it was much more difficult to do. Text messaging and the availability of instant communications and the availability of the instantaneousness of cloud deployment models make it much easier for there to be contract problems that come up. So I don't know if any of you work in this environment at an enterprise level, but what does an enterprise do to sort of get its arms around that? What would you do if you were the CIO for a company and you had 100 mobile devices in the field? What would sort of you think that maybe one way to approach this issue would be?
Deploy an MDM.
Pardon?
Deploy an MDM system.
Yes, good. That's good.
What do you say?
Deploy a mobile device management system, an MDM.
Yeah, it takes over your.
Good.
And then have a policy and educate the employees on it.
That's right. Where I was going with that is many times it's important for the legal department, again, it's a legal issue, the legal department to work with HR to make sure that you have policies in place that govern how your workforce is using its mobile devices in the cloud, to make sure that those types of things are guarded against. So let's assume now that Reed has done that. And HP management says, we decline to honor that contract that Reed entered. We decline. A lawsuit ensues. What's going to happen? Just play it out in your minds. Play armchair lawyer for a minute. What's going to happen? You're the lawyer for the aggrieved customer. What are they gonna say? Reed told me, parent authority. Reed told me that we're gonna get it for $389. What does HP say? The HP's lawyer for the pardon me? That's right. That's funny, but that's exactly the right answer. Why does he no longer work for you?
Because he breached his contract and terms of service.
Very good. So again, we think about litigation. The reason we do this is so that when you are deposed, you're the HP vice president over Reed. Reed's been fired. They're going to take your deposition because they're suing for $10 per 100. That's $1 million, right? They're suing for $1 million. In your deposition, your lawyer will coach you and say, when they ask you about Reed Disney, here's what you say. Reed Disney was a rogue employee who violated HP's social media and cloud computing policies. His employment was terminated effective the date he sent that text message, and we have no responsibility for Reed Disney's behaviors in contravention of our stated employee policies. That's exactly what you say, just like that. And your lawyer will coach you to say that.
Isn't the truth is if someone ordered 100,000 plus social media today, we could sell it.
Yeah.
I'm sure $10 off would be great. I'm sure they're getting asked for a lot less.
The downside for Reed though is if they're successful in doing that, now you're liable on the contract.
That's true.
Right.
In fact, as to Phil's point, that's exactly right. The converse of that is true. There was a recent case in which that exact fact pattern arose. A sales guy sent a text message altering the terms of a contract. The court went the other way. The court found for the plaintiff, and it caused a $1.2 million damages award against the defendant company, Reed's employer. $1.2 million.
Just so that they sued the employer?
Yeah.
The employer doesn't.
Well, the employer, yeah, they sued Reed's employer, the company that made the contract.
But do they then sue Reed? Sorry, Reed.
No.
My reputation comes.
Reed has been fired. They're not gonna, they'll just sue Reed. They're not gonna go after Reed. Yeah. But his employer will have to pay the damages, the difference, the 10 times the
Former
$100,000.
employer.
Former employer. Yeah, that's right. All right, so
That
the only
assumes that employer had policy, had
Right.
social media policy.
very good. It assumes the employer had a policy. So what is the takeaway? What's the cloud moral of the story in the contract space in terms of
Beef up your legal
policy? Have a policy.
Yeah.
Have a policy. And enforce
So
it.
is that any different because it's a text or it's an email versus verbal? So if I had done the same thing
Yeah.
5 years ago and verbally said, done, deal's done, let's, I
Yes.
change the contract.
And the reason it's different, Reed, is because of proof. The ability of the plaintiff to prove the case. 5 years ago, they would have said, but Reed said on the phone. And what would HP say? Well, no, he didn't. And you can't prove otherwise. You don't have a recording of the telephone conversation.
Okay.
The difference is it's a matter of proof. They have a copy of the text message that you sent. That's why it's different. And that's why the cloud makes all this so messy, is because there's now a record of it, right? Everything's permanent, everything's forever on the internet, and that really is true as a general rule. Okay, any other questions about some of the contract problems that the cloud creates for us? Just an example, and this is exacerbated by the move to mobile. I think we've talked about that. So lastly, let's talk just a little bit about social media, the cloud and social media, and some of the legal issues around that. It's very much like this, but let's imagine that, I always think in context of the enterprise because I typically represent IT departments, but you have an employee who has been tasked to create a new website for a product that you're going to launch, right? The employee knows that the website requires 10 photographs of trees with children around them. I don't know, whatever. Well, the employee has a decision to make at that point. The job has been mandated. I need to put up a website. I need 10 photos of children and trees.